Hello, this is Mr. Kidwai. In this video, we are going to discuss three models of law as addressed in our Intro to Criminology course. If you have taken other criminology courses or perhaps sociology courses, you will quickly notice some overlaps. The three models of law are consensus, conflict, and interactionist. Each model views the legal system, how it functions, and citizen interaction with it very differently. They take uniquely different perspectives on how laws are made and why criminals are, well, criminals. Let's start with the consensus model. This model can also be called the systems model, although we will stick with the name consensus model. This model is quite popular in the United States, in part because democracy depends on it. That's assuming, of course, that democracy is working correctly. The model is in part influenced by popular political philosophers such as Rousseau, Locke, and Hobbes, all three of whom had profound influences on the Founding Fathers. Rousseau, Locke, and Hobbes all believed in a social contract. This is a popular notion even with more recent political philosophers such as John Rawls. At the heart of the social contract approach is the notion that man, in the state of nature, is evil. In the state of nature, we simply look out for ourselves. We want something and we will throw a tantrum to get it. We want something and we will take it. We may even kill for it. Society cannot operate in this way. In the state of nature, we must always be on our guard. In order to ensure our safety, we choose to enter into a social contract. This is an informal contract in which we agree not to harm others, and others won't harm us. Essentially, we agree to abide by laws. Members of a society enter into a social contract. Think of it this way. We, as a society, come to a consensus that we must obey the laws in order to protect ourselves and others. We establish consensus around the norms of our society. There are three categories of norms: folkways, mores, and laws. Please note that if you have taken an Intro to Sociology course, depending on the textbook you use, the three norms may have slightly different names and meanings, and they may even have a total of 4, depending on the textbook in the class. However, for this video, we will focus on these three here: folkways, mores, and laws. Folkways are informal norms. These are things we are expected to do. They are largely issues of politeness. For example, not talking on the phone while in line at a grocery store. Perhaps holding the door open for the person behind you. Don't pick your nose in public. If somebody violates these folkways, we might give them a strange look and maybe be a bit upset. However, there won't be a formal sanction. They won't, for example, get arrested. Mores are norms that are more strongly held by members of society. If we break these norms, mores, we might receive a harsher sanction. For more information about these types of norms, feel free to watch the video linked in the description below. For now, we should focus on the last type, laws. Laws, of course, are formal norms, typically formalized in legal policy. These are norms that we have the most consensus around. We as a society agree that certain things simply should not be done so that we can protect ourselves, protect others, and protect our society. For example, we agree that we should not kill, and as such, we have laws against it. Laws have several purposes, 3 of which we will discuss briefly here. First, laws allow for conflict resolution. If we are unable to resolve conflicts, we may have a breakdown in society. As such, the legal system, relying on laws that citizens agree upon, attempts to resolve conflicts. Think of the court system. A second purpose of laws is social control. Due to the state of nature, man cannot be trusted. Man left to his own devices will run amok. So we need laws in order to control us and keep us in line for the safety of others and for the smooth function of society. Lastly, laws help push forward society. Laws help push forward social change. Laws help society move forward and change with the times. Consider vital Supreme Court cases, such as Brown v. Board of Education of Topeka, in which the Supreme Court of the U.S. ushered in a wave of change by declaring, among other things, that separate schools for blacks and whites is unconstitutional. Laws help push us forward as society changes or should change. The consensus model believes that citizens have a direct say in what laws are established. They believe that we, for the most part, agree to them and help establish them, hence the term consensus. We help to establish laws by voting or contacting our elected officials, or even by protesting. Our elected officials act based on the interest of us, the people. Based on what we want, they represent us in our democracy, and they pass bills accordingly. In summary, the consensus model believes that society operates smoothly. This is thanks to general agreement over what laws should be, as well as the interconnected aspects of our legal system. People voice their opinions, and politicians respond accordingly. Police officers enforce the law to protect us. The judicial system also helps to enforce the laws, judges, court systems. The various components of our legal systems work together and operate smoothly. This connects to the next key idea. Our legal system serves the interest of the people. After all, the people are the ones that help to make the laws and elect the political officials. As we said, the various components of the legal system work together. And lastly, criminal acts are those that society has deemed as having significant negative impact on the interests of society. The second model of law that we will discuss is the conflict model. Think of everything we just discussed in regards to the consensus model. The conflict model disagrees. The conflict model does not believe that people actually rule America. They believe that citizens should rule America. They believe our voices should be heard and politicians should do as we say. After all, that is a core component of representative democracy. However, just because something should be a way doesn't mean it actually is. Wanting it does not make it so. In the conflict model, they don't believe the United States and our legal system operates in this way. They believe that the powerful control America and the remaining taxpayers, citizens, are left underwater, left struggling. The powerful, such as those in charge of banks and other corporations, are able to influence politicians so that politicians pass laws that are not in the benefit of the people, but instead in the benefit of corporations. The conflict model argues that laws should be passed on what people want. However, they believe this is not done. They believe that laws are instead pushed through the system in order to help those that have the most power. Keep in mind that they do not like this. They believe that society works in this unfair way not because they think it's appropriate. They think that society operates this way because it's simply what they see. They look out into our society. They see our society as one in which the powerful create the laws that help the powerful at the expense of everybody else. That using campaign contributions and lobbyists, powerful individuals get the laws made as they want it, while everyday people get ignored. Take, for example, Queenie's social reality theory, which you may have come across in perhaps a deviance class. The theory has 4 steps, as seen here. First, laws are made by the dominant class. The dominant class does not make laws based on what harms society. Instead, they make laws based on what harms the powerful, what harms themselves. And they're able to do this because they are in the legal system. They may be politicians. They may be lobbyists who have influence over politicians. They may be running corporations that work with politicians. And these overlap, as politicians might also serve on the boards of influential lobby organizations or corporations rather. Second, law enforcement by the criminal justice system for the dominant class, meaning the dominant class is able to apply laws to protect its own interest. Using police departments and judges, the powerful enforce laws upon everybody else. Well, primarily those that lack power. So laws that might affect them go ignored. They don't pass laws or enforce laws as much that might impact them, such as focus on white-collar crime. Instead, they focus on blue-collar crime. Third, criminal acts by subordinate groups. Meaning, people are pushed into breaking the laws not because they are bad people, but because of their living situation. Think of the vagrancies laws of our past, in which being unemployed could be considered illegal. So then you might be arrested for being unemployed and forced to work for free while arrested. Or consider times of high unemployment, or times in which there is a large gap between the rich and the poor. And that includes today. After all, the gap between the rich and the poor today is the largest it has been in nearly 50 years. Queenie's social reality theory argues that individuals are pushed into breaking the law because they have few other choices. For example, perhaps when we give tax breaks for same jobs overseas, when unemployment rises, some individuals are compelled to break the law by stealing or selling drugs, not because they necessarily are bad people, but because they have few opportunities. They have a tough time finding a job, and the jobs they do find are paying below a living wage. So that is stage 3. Stage 4, popular ideology of crime, meaning the dominant class uses those that break the law in order to create an ideology that reinforces their conception of crime. Rather than saying, well, crime is increasing because Americans are poorer today than they were in the past, and as such, poor Americans may be forced into crime to make ends meet, we instead say, look at these people breaking the law. This is a serious issue. We need to be more strict on crime. Rather than looking at why people break the law, the dominant class instead point the finger at criminals in order to justify unjust laws that benefit the powerful, such as for-profit prisons or companies that rely on prisoners for cheap manufacturing. They focus on crimes of the lower class while ignoring crimes of the upper class. In short, this perspective believes that the legal system is not designed to help the people. It is designed to help the powerful and the rich. They believe that the people do not have much of a say in creating laws, but rather it's the powerful and the rich that have the primary influence over law creation, and that they create laws not based on the interest of the people, but instead they create laws based on their own interest. Lastly, the interactionist model. We'll spend the least amount of time on this. Many books do not even mention this model, at least not blatantly. However, we will address this briefly now and in more detail later on this semester. In short, the model views society as a social construction. In terms of laws and criminals, people are labeled as criminals, not because they necessarily broke a law, but because we have labeled them as a criminal. Likewise, someone may break a law and not be labeled. They may get away with it, or we may write them off and say, well, it's simply a mistake. While others, we label as a criminal even when they might be innocent, or perhaps they feel guilty. It's all about the label placed upon a person or not placed upon them. Individuals can also be labeled without even doing anything. For example, someone may be arrested for murder, but be completely innocent and still be convicted. It happens. There's a long history of this happening, of course. Or some groups may be punished at a harsher rate for crime that they're less likely to occur. For example, blacks are more likely than whites to be arrested for marijuana use, even though blacks are less likely to actually smoke marijuana, less likely to use marijuana, but more likely to be arrested for it. This is because we are more likely to label blacks as criminals than whites or Asians. Labels do not have to correspond with the reality, or rather reality is whatever we make it to be. We as a society attach a stigma to people based on the way they look, based on their social class, based on the jobs they do. This means laws and their enforcements are not based on the good of society, as would be argued by the consensus model. Instead, they are based on labels that we apply to people and are subjective standards. Criminality is less about an individual breaking a law and more about how we label some individuals as criminals while ignoring others. With that, we are just about done. You may have had an aha moment when watching this video, in particular if you have taken other criminology courses or sociology courses. Much of what we discussed here is also discussed in other classes. For example, consider how these three models of law, as addressed in this video, might relate to the three major perspectives or paradigms discussed in Intro to Sociology. Just something to ponder. If you make that connection, by the way, it will help you even more in understanding these three models here. Well, I hope this video was useful in helping you to understand the three models of law, and have a great day.